2 o'clock. Good afternoon. Welcome to the City of Titusville. These are public hearings for code enforcement violations. These hearings are quasi-judicial. I am the special magistrate appointed to hear the cases. Formal rules of evidence do not apply, but fundamental due process shall be observed. Everyone who has a case today will have an opportunity to present testimony. You may present evidence or witnesses to testify on your behalf. There's no public comment portion. You must be a respondent or a witness in order to speak on a specific case. Everything today is being recorded, and all testimony will be under oath. When you are sworn in, I need you to provide your current mailing address so that any orders get to the right place. The city will present its case first, and information will be displayed on the screen. Documents may be provided by the city as evidence. The city will have a PowerPoint presentation, which will be entered into evidence unless objections are made. After the evidence, I will make a ruling. That ruling will be reduced to writing and mailed to you. At this point, we will swear in all witnesses. Anyone who wishes to give testimony on their own case, please raise your right hand. Any code enforcement officers testifying, please raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth? I do. Thank you.
Good afternoon, ma'am. How are you?
Good, thank you.
Our first three cases this afternoon are going to be reduction requests. And we'll go ahead and start with the first one, 21-8. That case was originally heard in 2021. It's changed hands, and the current owner, Titus Holdings, are here to provide testimony in their case. They're asking for a reduction lien in the amount of $74,000. I've sent forward the applications for your review. And with that, I will turn it over to Mr. Mahays or his representative, to whomever.
Okay. Does the city have anything in terms of like pictures from of the violations or?
No, ma'am, I did not.
Okay.
It was actually put in compliance December of 23, and they're all still currently in compliance as of today.
Did they all come into compliance at the same time on December 11th, 2020?
For that property, yes. For the current property of Chester Drive, yes, ma'am.
Okay. All right, if the applicant wants to come up. If you could please state your name and your business address.
Yes, my name is Heath Moeller, and the business address is 310 Cheney Highway, Titusville, Florida, 32780.
Okay, and your relationship to the owners?
I am his real estate agent and assisting him with the property management for Titus Holdings.
Okay. All right. What would you like to present?
The main thing I wanted to mention was when we purchased the property, we weren't aware of the code violations at all. We were made aware of the code violations approximately 3 days before the closing in December of 2023. At the time that we were made aware, we immediately engaged not only the city, but also the prior owner or the contractual who we thought was the owner at the time. And long story short, there were some issues with the title, et cetera, that we had, once we figured that out, that we needed to start working with along with, that were exacerbated by the code liens that apparently had been accumulating for some time. I mean, it's a large amount. So at that point, we had a decision to make whether we're going to continue or not, basically. And we had a substantial amounts of money in escrow, et cetera. So the determination was made to go ahead and continue. So then we immediately, as I mentioned, engaged the owner or the person we were under contract with at the time, and we brought the property into compliance. We did escrow an amount of money to have that to make that happen, just for security for the current owner.
Did you escrow money to pay fines?
We escrowed some money to pay fines, correct.
How much did you escrow to pay?
We escrowed, I believe, approximately 50% of the outstanding amount. I don't have the exact figure with me, unfortunately. And so the request to reduce was, basically a function of the new owner not having to, bear the burden of the entire amount, just because obviously we had no clue. But we also were invested in the property, so to speak, at the time. So that's where the number came from. And I don't know the codes and all of that in the new statutes. Obviously, I know you guys do that every day, Your Honor, but I know there's no, I guess, was it minimum or maximum reduction now? It's all negotiable, or there was a time when there was
a
a
lien amnesty
threshold.
program.
Okay, yeah. So we want to try to get, obviously, the most reduction that we can based on the circumstances, or to at least actual costs. Because at this point, we still don't have an actual breakdown of what $70-something thousand equates to. We've never been given that. So not that, or the actual costs. So that's all that I have at this point. I mean, we've brought the property into compliance and then some right now. So it's going to be a desirable property for the neighborhood. The property is completely cleaned out. There's full-time maintenance. Actually, the code enforcement's been actually phenomenal to work with as far as just engaging them. It was sort of a unicorn, so to speak, in terms of purchasing the property and then bringing it into compliance like in real time, which has happened.
So how did you get past the closing without paying the liens? Just escrowing the?
It was an all-cash sale, so we just escrowed, it was just at that point privately escrowed between the parties, to come to an agreement. It was sort of like, hey, if this is going to go through, these are the assurances that we want. And so then this piece that we're at right now is the last piece to figure out what essentially is gonna happen. So.
And was there title work done before you entered into the contract?
No.
Could you please repeat the dates of when you closed and when you found out the information about code enforcement?
I don't have the actual date of closing with me. I believe it was in December 2023, but there was a time span that we did know about the code enforcement liens. It's just between getting back to the code enforcement and between the current owner, and the seller at that time. It wasn't long. I'm approximating this. It may have been a week or two, something like that. And then it took, some time to get into compliance. And then again, this was going to be the separate piece that needed to be handled. So
it looks like you actually brought the property into compliance before the closing date?
correct.
Well, that's terrific.
But that didn't negate the fact that just apparently stopped the daily fines, is my understanding, at the time, of which had been accruing for some time. But it just shows that we weren't, that we were progressing to this point, that we wanted to stop that. So.
Does the city have anything to add? Yes.
I would just like to ask Mr. Mueller a couple questions.
Sure.
Could you repeat your business address?
It's 310 Cheney Highway, Titusville, Florida, 32780.
Are you at all affiliated with approved statewide title?
I am. I'm a part ownership of that.
Okay,
Title
so do you
company.
know who Claire Matthews is?
Yes, she's a title agent. She's the manager of the title company.
And you said that there was no title search done for this property?
There was a title search done, but we didn't have the full title until right up until the closing.
A week before the closing?
Approximately, maybe a little bit before that, as far as the code enforcement and everything else went.
And you knew about the code enforcement daily fine and decided to proceed with the
That's
closing?
correct.
Okay, so
Yes, ma'am.
the statements made that there was no knowledge doesn't make sense to me because the title search did produce a daily fine total sheet with the corresponding liens. I have a copy of the email that my office, which provides the responses to lien inquiries, made to Mr. Muller's office with.
I didn't see that respectfully. That may have been the case. I may not have seen it because I was operating on the real estate side of things for the owner, not the title company side. So I just personally didn't see it, is what I was referring to.
You and I had a phone call before the closing.
Yes, ma'am. Yes, we
And we
did.
talked about this.
We did.
Okay.
Correct. That's correct.
Do you need to look at the email that the assistant city attorney
No,
had?
no, I'm sure that it came through, but I don't recall it at the moment. So
Okay.
that's all I meant is this.
And the breakdown that was provided, what did that include? Did that include a breakdown? I know
Yes,
I
yes,
got
ma'am.
some documents. I don't know if he
Yes,
got it.
yes, ma'am, I can provide it, let's see.
Is that this?
Yes, ma'am.
Okay, that's the one you gave me. This,
Yes, ma'am, and that was the one that was afforded to the title company.
okay.
So
If you have an extra copy, go ahead and give it to the gentleman. So the daily fine total, this is a code enforcement worksheet. Looks like it's dated 12/6/2023. I got this before today's hearing. This has a number of what I call non-reducible liens, which are the lot clearing liens, which are 1, 2, 3, 4, 5, 6, 7 of those. Those are not code enforcement liens that I don't have any authority over those liens. And those are hard costs. Those are the city's hard costs, which I would not reduce. So any kind of reduction of the code enforcement liens would have to be contingent upon the payment of those lot clearing fines, assuming they have not been paid.
No, ma'am, they have not.
Okay. The board administrative costs of $174.83. I also am not capable of reducing that because that's specifically in their code, that any reduction shall not include the city's administrative costs. My authority is over the 4 fines that you see, the second, third, fourth, and fifth one. And by my calculation, that totals $75,925 for those particular liens. I certainly commend you on your swift action in getting it into compliance. We don't usually see it happen that quickly. And I would like a little more information in the future from the city in terms of like pictures of what the violations look like, and because some of the criteria I have to consider concerns the gravity of the violation, how bad it was, also whether the applicant has had any previous or subsequent violations. I assume this applicant has not had any.
Yes, ma'am, and I do apologize for that as far as the pictures. However, before these cases will come before the board, I ensure that the applicant or any other properties or associations are clear of code violations and/or fees
Okay.
that are owed to the city.
Great. So looking at the criteria, the gravity of the violations, This was weeds, if I remember right, weeds, a dead tree, general exterior maintenance, which I don't specifically recall what perhaps Officer Wright could refresh my recollection somewhat. And to show this gentleman too, anything you have.
So I do have a copy of my Massey hearing presentation on my laptop. Would you like to see that?
I would, if you could show this gentleman first and then show me.
So we had, that was the picture of the property, the overgrowth, the dead trees.
From 2021.
Yes, sir.
Okay.
That was the original case.
Okay.
Oops. And those were, there was a fence in the backyard that was falling down. The soffit was missing, the rotted fascia at the bottom of the,
Okay.
so yeah.
Got it. Was that on the website at any time, or just, that's your guys' report to them, basically?
This is my presentation when this was for
When it was
Massey hearing.
active? Okay,
Yeah.
got it, okay.
Yes, sir.
Okay. Thank you.
This is from the Massey hearing. So it was the overgrowth, the dead trees right in that front corner. Right. The exterior was the rotten fascia, or rotted soffit, and then the exterior wall all along the edge was rotten. And then the weeds and obvious. Yep. And that was the back.
Confirmed funds in December?
Yes.
Okay.
From that.
Would you say any of those violations were serious health, safety, welfare type violations?
No, they were nuisance. The property had been vacant for multiple years. So it was just more of a nuisance violation than public health, life safety.
And before this party purchased the property, had anyone been using the property, living in the property that you were aware of?
No, ma'am. I did get contacted in December by the previous owner. I don't know if you want me to identify them or not.
I already looked up the ownership
Okay.
record.
And he received a copy of your order from, after the Massey hearing, the final order. I also met him out on property to walk through the remaining violations and direct him exactly what we were looking for compliance.
Okay, all right. Mr. Mullen, if you don't mind coming back up. What's the intent for the property? Are you intending to rent it out or?
Yeah, the owner, who's also present here today, is the intended use, and they've already started, is to make it a viable property again and to make it a rental. The property's been completed as far as completely cleaned out and is going to be started work on with all any permits that are needed or whatnot, like it would normally be. And then ultimately, the goal is to make it a rental.
Okay, so to put it to productive use.
Correct, yeah, to basically make sure that it's a viable property again for the city.
All right, anything else from the city?
No, ma'am.
Assistant City Attorney?
I just want to reiterate that the city did provide information about the code enforcement liens to both the person standing before you as well as the prior owner. And I had lengthy discussions with several individuals about the lack of the continuing of the amnesty program, as well as the nature of the violations and what was needed to correct them. And corresponding with Officer Wright's testimony, the prior owner did also put in a lot of work to cleaning up some of the violations as far as I know. So a lot of work was done prior to that closing, and it wasn't necessarily all done in a week's time.
Okay, understood. All right. Got my calculation. Okay. Now, all I can do is give a recommendation. I do a recommendation, and then the city council hears this at their next available meeting. I'm not sure how you guys have set that up.
Yeah, yes, ma'am. Once I receive the written orders, then I will prepare agenda items to the council.
Okay, thanks. So it's a two-step process to get a lien reduction. As I discussed, I cannot do anything about the lot clearing liens, and I cannot do anything about the administrative fine of $174.83. So my authority is over the $75,925 of accumulated fines. In this case, after taking in the testimony and the evidence, and looking at the criteria in the code, I find that in terms of the gravity of the violation does not warrant any immediate concern in my mind that the lingering nature of these violations were a health, safety, welfare extreme issue. The actions taken by the applicant to correct the violations, there was a quick curing of the violations, whether it was exactly by this applicant or in conjunction with the previous owner. It did appear that once you were aware of the violations, they were cured quickly. Any scheduled maintenance plans to avoid future repeat violations? I thought that you had said something about you have some kind of full-time maintenance person?
Correct. Yes.
Okay.
And they're actively working on the property as we speak, so.
Okay. The accrued amount of the fine compared to the current market value of the property. I saw on the property appraiser's website that the market value of the property, which we all know is not really fair market value, was $130,000 or something like that. I'm not sure the exact market value of the property, but the $75,000 is a pretty decent chunk of that property appraised value. Any previous or subsequent code violations committed by the applicant? None. The applicant's prior knowledge of the lien, I do find that you had knowledge of the lien prior to the closing, and you chose to move forward with the closing despite knowledge of the liens. Any financial hardship, I have not received any testimony that this bears a financial hardship other than, you want to make a good business deal, so you don't want to pay an amount of money and then have a chunk of it taken by liens. Whether the property has a homestead exemption, I'm going to assume that's a no. Any other mitigating circumstances? I don't really find that there's any other mitigating circumstances that apply here. So looking at the $75,925 total amount that I have authority to review, I am also considering the amount of money that was escrowed. I am going to recommend a reduction to $30,000 from $75,925 to $30,000. And then that will, I will put this in writing, and it will be mailed to, well, it is typically going to be mailed to who's ever on the property appraiser website as the owner. Do you want a copy mailed to you as well?
Yes, please. Thank you.
And then the city will be in touch in terms of when it will be on the council agenda.
Okay. Thank you. Okay for me to go?
Yes.
Thank you, Your Honor.
let me finish my notes here. Okay, ready for the next case?
Yes, ma'am. Actually, the next two cases are also for a reduction. The same owner, Ms. Tina Russo, 945 Palermo Road and 940 McGuire Drive. And this case came to us in May of 2023. Ms. Russo had hired a contracting company to re-roof three of her homes. And one of those homes she was allowed to get a permit for under the owner. Other two, the building department required a contractor. She was unable to get a contractor to sign off on that. She's worked on it since then and has actually been able to get those permits issued and finalized. And Ms. Russo's asking for a reduction of $12,850 in each one of those cases, which is the total fine for each one.
All right,
And Ms. Russo is here.
Hello.
can you go ahead and state your name and your address?
Yes, it's Tina Russo, and it's 865 Glenda Drive, Titusville, Florida, 32780.
Okay, what would you like to say about this one?
Well, exactly what Mr. Tolson kind of said is where I'm at. I did have 3 roofs installed in September of 2022. I was, of course, under the understanding was that my license was, or my contractor was licensed. He put his name down on the receipts, and it was all fraudulent. Anyway, code enforcement came, and of course, seen him working on the roofs. And at that time, I was not home. I was caring for my father. My sister was home. But anyway, really, that's no here or there. I did find out by him that I needed to pull my permits, that he was not licensed, that I could pull one for my home. And I actually thought I could pull one for my rentals too. I was unaware of that. So I did pull one for my home when I got back. Then of course I found out I can't pull for my rentals. So it was a hard year for me. It was, it would be for anyone, but I did try. I could not find a licensed roofer that would take on this job and sign off responsibility.
Had the previous one finished the roofs?
All 3 were
all three?
finished.
Okay.
Yes, ma'am. It was just before the hurricane. I had renters, and all 3 of my roofs were leaking. So it was one of those where I couldn't kind of stop at that point. I wanted to just finish it and then figure I could figure this out on my own. I did last year contact several structural engineers, thinking that they would be able to sign off on the permit or to go and actually pull a permit. I did have one that was willing to, but the city official, Steve Adams, I think it is, denied that and said I would need a roofer, an actual licensed roofer. So, I mean, I was out on the streets contacting every roofer that I could find, and no one would do it. I finally, this year in March, found someone that would do it for me. And he pulled them and they passed, and I'm in compliance. I'm asking for the reduction of, I think you have it, the 20, oh, I have it right here, sorry. I think it's 25,700. That might be with the. It's the 2 combined,
Yes,
I'm sorry.
that's both combined.
Yes, both combined. And of course, I'm willing to pay all hard costs, administrative fees. But that's what I'm asking for. And that's kind of the situation.
Okay. So basically, you're your defense, for lack of a better word, is not that you didn't know about the violations, not that you didn't know about the liens.
Correct.
It was just you had a hard time finding someone to help you bring the properties into compliance.
Correct.
And you made a diligent effort.
A diligent
Correct.
effort. And I finally, when I got this one, the only way that he would do it, of course, was signing off a waiver of responsibility, which is fine. And I understood that, but to me, it was
Yeah.
whatever you need.
Do you have an estimate of the market value of each of these
Of the
rentals?
homes, I don't. I don't have it.
Officer Wright?
Well, good, I can see what the value is.
So the first two tabs open.
Okay, so the current market value of well, Glenda Drive, that's where you live, right?
Yes,
Okay.
ma'am.
So this one is this is 945 Palermo.
Okay, 945 Palermo. It says the current is 141,000. Yeah, it went down from last year. That's odd.
And then this is for 940 Margie.
940 Margie, the property appraiser shows 151,000 for the 940 Margie. Okay. Thank you.
To see the previous photos.
I remember this case, so I don't, yeah,
Because I haven't.
thank you. Okay. Anything from the city?
I just want to add that Ms. Russo had stayed in constant communication with me. She left me messages and we had conversations about what she needed to do, and she let me know every step of the way how much she was working towards compliance, and I just want to applaud her for her efforts and thank her for communicating with me.
Very good. Do we have, other than the standard, time it takes for the code officer to go out and make the inspections and the mailing costs, any extraordinary costs of the city in this case?
No, ma'am.
I would ask the applicant, did you have to pay double permit fees for after-the-fact permits on your 2 roof permits?
I think it was double. The contractor did it. I don't remember the exact amount because he kind of put everything together in a total bill for me. But I know that they doubled on my home when I did it, so I would assume they probably did.
Okay. Well, in looking at the factors under the code, and as I explained earlier, I don't have any authority to reduce the administrative fines in the case, which in 945 Palermo, it was $198.97, and in the Margie Drive, it was $146.14, so I can't touch those, so those will have to be paid. Considering the factors that I have listed in the code, I find that a substantial reduction in the total fines would be appropriate. I'm going to take one at a time. On 945 Palermo Road, the $12,850 fine, I'm going to reduce to $2,000. And on 940 Marjorie, I will reduce to $2,000.
A time frame on paying these, do you know?
This will first have to be put in writing. I will enter an order. It will get sent to the city. They will mail it out, and then they will contact you when this goes to the city council, because I'm only making a recommendation to the city council.
Okay. Is this like a final, or is it something that can be
If the
adjusted in any
city
way?
council has a different thought, on this, and you certainly have the opportunity to request a different amount, then it could be higher, could be lower.
Okay.
Depends on the city council, how they determine these
Okay.
types of cases.
And do I go to that hearing?
That is, if you want to, and I would recommend that you do attend.
Okay.
Since you are the person bringing this application, you will want to attend.
Okay,
And then
Okay.
you have a period of time that's in the code in order to pay those amounts.
Yes, ma'am, 90 days after
90
the
days.
council's ruling.
Yeah,
Or as otherwise ordered by city council. So if the time frame of 90 days is not enough, then you can ask city council for special consideration, but they're not going to go too much longer than the 90 days.
okay.
okay.
Yes, one more question on that. Whatever the amount is final, does it have to be paid in full, or is there a way to make payments in it, or does it have to be totally paid?
I would assume it's a total payment, or else the original fine reverts.
A partial payment would be credited towards the total amount, but you won't get a release until the total amount's due within the specified time frame.
Okay, gotcha. Okay, thank you very much.
All right,
But if she wants to go ahead and pay those hard costs, she can do that at any time.
yeah, those
Because
hard
those
costs.
would also, they would have to be paid before it's cleared.
Everything is conditioned on the payment of those fines, so that would be a condition of getting the lien reduction, is paying
Okay,
those city's costs of prosecution.
okay. One more question, and I'll leave you alone. If I wanted to ask for further reduction, would I ask that through you, and would you submit that,
You
or
would do it to the council that
to the
evening.
council? Okay, gotcha. Okay. Thank you very much.
Thank you.
And I'll contact you next one and give you a copy. Now that takes us to our Massey hearings today. Our first case is Orca Properties, 4265 South Street, Officer Wright. And we do have a representative of Orca Properties present as well.
Okay, Massey case, 2362, Officer Wright.
All right, I have one item to submit. It is the affidavit for the notice of hearing for today's Massey hearing.
Thank you. Admitted into evidence as City's Exhibit 1 is the notice of today's hearing and the affidavit of service.
So once again, this is case number 23-62, the Massey hearing. Respondent is Orca Properties LLC. Our violation address is 4265 South Street. The one violation was of section 6-56, construction permit required. So again, this case was originally heard on December 11, 2023. The respondent's representative from Appliance Direct attended and provided the testimony, and he is here again. The respondent was ordered to correct the violation on or before April 5th, 2024. To correct the violation, the respondent was ordered to obtain permits to address the work to the yellow metal building and the underground electrical work. You also granted permission for the electrical conduit in the ground and in the trench to be removed and the area to be backfilled to prevent erosion and damage to the parking lot. So if compliance was not achieved, a fine in the amount of $100 per day to commence on April 6th was ordered. And the administrative costs in the amount of $234.19 were imposed. So per the building department records, no permits have been issued at this time. The last activity noted on alteration permit number 22-3611
showed updated plans were submitted for review on January 4th of 2024. And corresponding review comments were emailed back to the applicant January 16th of 2024. There is yet to be any response to those January 2024 comments. So once again, this is the property, 4265 South Street. The area in yellow is where the work was done. These photos are from March 27th when I posted the property. So again, at this time, no permits have been issued for the work. No work has been done at the site.
What about that trench with the
That's what this picture is right here. It's still open.
still open?
The conduit is still in the trench.
Yeah, I gave a lot of time. Okay. Anything else from the city?
Not at this time.
All right. Would the representative like to come up? And if you could, once again, give me your name and a business address.
My name is Mitchell Biedel, Biedul. The address is 397 North Babcock Street, Melbourne, Florida, 32935. And I would like to say we have secured two subcontractors, Jones Plumbing and Advent, that I submitted to the city of, to the building department, the subcontractor authorization forms. I did submit those. The one thing that has held us up a little bit is the contractor ended up in the hospital for 2 sessions in the hospital, first time the end of January, and then again in middle of March. And that's kind of slowed us down a little bit. So what basically I'm requesting is that if we can get another, if not another, but an extension. He's recovering at home right now. We're probably in the midst of probably looking for another contractor at this point too. So we're kind of up in the air on things.
What
But,
was that contractor supposed to take care of?
the actual contract, the
work?
The work, yes,
That
ma'am.
was cited in the violation notices. Okay, and the code officer mentioned that there were comments from the city provided in January, but no one has responded to those comments.
To the comments, as far as filling in the trench, no, we have not done any work at all on the property. We did on the, she had the visual of the property on the north side of the property. An officer Enright, site inspector, asked that we were actually cleaning out our retention ponds. And he came by and asked if we would clean out the north boundary. It's a drainage into the St. John's. And we complied with that at our own expense, cleaned that up. But as far as anything, as far as the building is concerned, we have not done anything with.
But you did, but there was something submitted to the city though, right? Some kind of permit application, and then the city provided comments on the application?
We've applied, yes, for a permit. We had originally had a demo, reskinning permit.
Right, I recall that, but, Officer Wright, what was it that they had applied for in January?
That was.
So, January 4th, the applicant had submitted an updated application and comments. The building department did their review and emailed those comments of additional questions they had or additional documents they needed. I don't have that specifically. I can get a copy for you if necessary.
No, that's okay. I'm just asking, are you aware of that the city had responded to the application and had comments?
I had understood that they would come back, but like I said, right at that time, the contractor went in the hospital. So I know it was provided to him, to his email address, but he said he never saw it.
Okay.
So I did get about a week later, I came to the city and got a copy of it. And we tried to take care of what, from that point on.
So the problem with where we're at is this is just the compliance hearing. I can't extend the days to come into compliance because there was a pretty good period of time that I provided to get the building permit, get your application in.
Well, we've got the application in,
Well,
but we don't have the permit back.
right. So you have to actually get that.
Well, that's what we're working towards, yes, ma'am.
But I can't change, so that was in December when we had our first hearing, and I gave you until April 5th to obtain a permit for the electrical work and a permit for the repair or demolition of the yellow building by April 5th. And none of those things have been done. I can't change how much time I've given you because I thought that was an
Well, we did
extended
too
period of
until,
time.
like I said, and I do have his actual release patient discharge from the hospital twice. So I'm not making that up.
I don't think you're making it up at all. I know that kind of stuff happens, but I can't, then you try to, work around that or.
Well, we tried, yes, ma'am.
It's just not, I don't think it's appropriate in this case to go beyond what's normally done and give you an extension from April 5th. At this point, the property is in non-compliance. Doesn't look like really much of anything has been done to bring it into compliance. And
Well, we can't do anything without the permit, yes, ma'am.
April 5th is when the fines started running, or the fine in the amount of $100 per day. It's just one violation, $100 per day, starting April 6th, 2024. And those fines, I'm gonna impose those fines because the property's not in compliance. It's been running since April 6th and will continue to run until compliance is achieved. You always have the opportunity to come back for a lien reduction.
Right.
But the goal right now would be to get
Get a
it
permit.
in compliance as soon as possible. Obtain the permit for the electrical and a permit for the demolition of the yellow building. Anything else from the city? All right. Well, thank you, sir, for coming. I
Thank you, ma'am.
appreciate you taking the time.
Not a problem, thank you. Thank you.
All right, next case.
Yes, ma'am. The next case, 24-09, Toby Smith and Eunice Smith, 2247, Officer Flynn.
I really don't have anything to present due to the fact that this is in compliance.
In
The trailer has been
compliance.
removed as of a couple weeks ago, so we're good.
Great.
And it was before the date of
Okay.
needing compliance. So.
Does the city want the imposition of the costs 26914?
Yes, ma'am.
Okay, so I'll go ahead and enter an order finding the property was brought into compliance and impose the 269.41.
And just as a reminder, the city requests that the title of that order include finding compliance and imposing costs.
Yes. Okay. Initial hearings.
Yes, ma'am. Our first case, 24-12, Victor Martinez, 4440 Swift. And this will be Officer Wright.
So I have 3 items to submit. The first is going to be the affidavit and notice of violation. The second is going to be the affidavit for the notice of hearing. And the third is the cost recovery statement in the amount of $251.80.
Thank you. I will accept into evidence. Exhibit 1, notice of violation and affidavit of service. Exhibit 2, notice of hearing and affidavit of service. And Exhibit 3 is the cost recovery sheet in the amount of $251.80.
So again, this is case number 24-12. The initial hearing, our respondent is Victor Martinez. Our violation address is 4440 Swift Avenue, Titusville, Florida, 32780. The mailing address is 4455 Swift Avenue, Titusville, Florida, 32780. So as of today, there are 3 violations. The first one is section 12-23, junk and debris. The second is section 13-73, inoperable unlicensed vehicles prohibited. And the third one is section 609, the 2018 Property Maintenance Code, subsection 304.6, exterior walls. So the initial inspection was completed on May 26th of 2023. Date given to comply was on or before June 26, 2023. First class and certified mail was sent to the listed owner on May 31st, 2023, and the certified mail was refused on June 2nd of 2023. Notice of hearings were posted at City Hall and on the property on March 27th of 2024. First class and certified mail was mailed out on March 6th. And the certified mail was returned unclaimed, unable to forward on March 23rd of 2024. So this was a proactive enforcement. I was driving in the neighborhood and observed a unlicensed pickup truck in the front yard. I completed inspection from the public right-of-way, found grass and weeds over 12 inches in height, junk and debris around the exterior of the house and in the backyard. I also observed a broken window and damage along the north wall of the house. I took photos of the violation, and while on site, I did speak to the owner, Victor, and provided that notice of violation. So I've done multiple re-inspections on this property, including this morning. Mr. Martinez was there on all of those re-inspections. And I continued to push to get things completed and repaired. So again, this is the inspection photo from this morning. This is of the front yard. We've got jet skis, trash and debris along the front of the house. This is a closer photo of the front of the house. Again, we've got appliances, miscellaneous trash. This is the north side of the building. We've got building materials, junk, trash, debris. So this is a close-up of the exterior wall damage. We've got a damaged portion of block, and then fascia and soffit on the house, and the patio on the back of the house is damaged.
The patio was damaged?
There's the roof over the patio. We've got rotten wood, we've got deteriorated, damaged wood, and there is a hole in the roof that, until I was given permission to go in the backyard, I did not see. So the initial was only exterior walls. I didn't do a violation for roof. So this is the backyard. We've got a pile of scrap metal, various lawn equipment, just piled up in the backyard.
This is not the owner occupied, right?
No, this house is unoccupied at this time. Kind of uses it for storage. This is the back of the house. We've got tires, we have more appliances, we have abandoned lawn equipment, parts from lawn equipment, all stored against the back. This is the blue pickup truck that I initially saw in the front yard. It still is not registered or licensed. The overgrowth has been removed. It's just the trash and debris in the backyard being stored. So for the conclusions of facts, for section 12-23, we've got junk, scrap metal, discarded building materials, machinery being stored on the property. So for inoperable and unlicensed vehicles, the truck, jet skis are not registered at this time. And then for subsection 304.6 for the exterior walls, we've got the patio and the block on the north side of the house are damaged. So we are requesting an order be issued that the violations are corrected on or before June 7th of 2024. To correct those violations, we are asking all of the junk and debris be removed from the yard and from against the house and stored inside the house or within the patio. For the inoperable or unlicensed vehicles, we are asking that we either receive proof of current registration and demonstration that the truck and boats work, or that they are removed from the property. And then for the exterior walls, 304.6, we're asking that the block wall is repaired, the hole addressed, and any of the damaged or deteriorated wood on the patio and the roof be repaired and replaced.
Okay, and recommended fines?
And then we're asking that administrative costs in the amount of $251.80 be imposed. And we're asking for $50 per day per violation, starting June 7th, 2024. So again, I was on site with Victor this morning. He was not going to be able to attend today, but he did feel he would be able to get the violations corrected within that time frame that I have asked for.
Okay. All right, thank you. I will find that the respondent was given proper notice of the violations and proper notice of the hearing. Respondent did not appear. There is, based on the evidence and testimony, there is evidence of a violation of 12-23, junk and debris extensive amount of junk and debris in the yard and up against the house. There is an unlicensed, unregistered pickup truck and also a jet ski that has to be cured by registering those items and ensuring that they are running. There is also a violation of Section 6-109, IPMC Section 304.6, exterior walls, broken glass block, damaged wall, damaged fascia, damaged wood, patio damage. Those items need to be fixed. The date for compliance will be June 7, 2024. If the violations are not cured by June 7, 2024, a fine in the amount of $50 per day per violation will begin to run on June 8th and will continue to run until each violation is corrected. The city's costs in the amount of $251.80 are imposed. Respondent is directed to contact Code Officer Wright when the violations are corrected.
May I make one correction?
Yes, please.
So June 7th is the Saturday, so we're asking for a compliance date of the Friday of June 6th. No, it's not? No. Oh, okay, I'm sorry, I had it wrong then. I'm sorry, I had it wrong.
So June 7th is the
Is the
compliance
correct-
date.
I'm sorry. My daughter's 8th birthday. Oh, okay, she knows.
That is embedded in her mind.
All right, good.
She's already planning the party.
I thought I messed up, so I apologize.
Okay, so ordered. Okay,
All right, thank you, I'm
thank
sorry.
you. You have the next one,
I do.
Yes, ma'am.
So this is case 24-13. The violation address is 4455 Swift Avenue. I have 3 items to submit. The first is the affidavit for the notice of violation. The second is the affidavit for the notice of hearing. And the third is the cost recovery statement in the amount of $234.19.
Thank you. I will admit into evidence as Exhibit 1, the notice of violation and the affidavit of service. Exhibit 2 will be the notice of hearing and affidavit of service. And Exhibit 3 is the cost recovery sheet showing a total amount of $234.19.
So once again, this is the initial hearing for case number 24-13. It is the same owner as the previous case. This time, the violation address and mailing address are the same, 4455 Swift Avenue, Titusville, Florida, 32780. So at this time, there is only one violation occurring at the property. That's section 12-23 for junk and debris. So this was a complaint issue or driven violation. The notice or the inspection, initial inspection was September 19th of 2023. He was given till October 4th to remove the overgrowth of 2023, and the junk and debris was to be cleaned up by November 3rd, 2023. First class and certified mail were sent September 20th, and certified mail was signed for on September 23rd of 2023. The notice of hearing is the same as our previous case, posted on March 27th of this year, and the certified mail sent on June 6th and returned unclaimed on March 23rd of 2024. So again, this was a complaint we received from the neighbors concerning the yard being over 12 inches in height and that the trash and debris had increased on the property. Once again, all of my inspections were completed with the owner available. So this is again from this morning. Our grass and weeds were cut and continued to stay cut. What we have is a large accumulation of trash and debris still along the front of the house. So this is the driveway. The backyard, we still have a little bit of building materials stored there. The motorcycle is in compliance. Lawn tractor is running. Got a few items on the back of the house, but it's the front of the house that is the main point of violation.
Looks just like a variety of,
Oh, we've got a little bit of everything.
Household
Boxes,
items.
we've got scrap metal, we've got building materials, we've got engine parts, we've got small lawn equipment. The tarp is covering a refrigerator that is plugged in and running. Yes. It's a running refrigerator, has items stored in it.
but it doesn't belong outside, right?
Oh, it's running outside. Yes, ma'am. It's plugged in. He currently uses it.
But it doesn't, it's not allowed outside, is it? Is that part of the?
If it's
junk and
running
debris?
and being maintained,
Okay,
it's for abandoned appliances.
okay.
He does have, now I can say that he does have a padlock on the
Okay.
front of it. It doesn't look great with the tarp, but it is a functioning appliance.
Okay.
You know, we have people with the same thing under their carports.
Okay.
So, conclusion of fact, 12-23, we obviously have abundance of items being stored in front of the house. We are asking that the respondent be ordered to correct the violation again on or before June 7th of 2024. We're asking that he removes all the unused abandoned vehicles, boats, boat parts, vehicle parts, machinery parts, metal, lumber, discarded building materials, cardboard boxes, etc.
There's other vehicles? Or vehicle parts?
There's vehicle parts on the driveway. I just pulled in everything from the ordinance section itself to kind of cover it. Because he does transfer stuff from one property to the other. So he was working on one and
Just moved it over to the other.
so we are asking that the respondent be assessed administrative costs in the amount of $234.19. If the respondent does not comply by June 7, 2024, we are asking a fine of $50 per day be imposed, starting June 8th.
Okay. I think you're a little generous with the fine recommendation on.
Our agenda for the May is full at this time, so there wasn't really room to put it on.
No, I mean, that your recommended fine on this one of $50 a day, I think you're being generous. All right, I'm going to find that the respondent was provided proper notice of the violations and proper notice of today's hearing. Respondent did not appear. Based on the evidence and testimony, I find abundant evidence of a violation of section 12-23, junk and debris. There is an excessive accumulation of trash and debris, especially in the front of the house and the viewing of the neighbors. And this was a neighbor-generated complaint. I will order compliance by June 7, 2024. Failure to comply by removing all unused, obsolete, abandoned junk items. Failure to do so by June 7th will incur a fine of $100 per day. And the city's costs are imposed in the amount of $251.80. And the
Ma'am, I
respondent is
think that
ordered to
was-
contact the code officer.
Ma'am, that was it was $234.19 for the cost recovery on
Oh,
4455.
right, I was reading the wrong one. $234.19 for the cost,
Yes, ma'am.
so ordered. All right, thank you.
Thank you.
Anything else on the agenda?
No, ma'am, that concludes our presentation for today.
All right, thank you. Thanks.
I'm gonna do my best.